Assalamualaikum and hi, my name is Nurhazat binti Baharudin and together with me is my partner Nurul Atira binti Hamid, and today we are going to explain about the case of Abdul Kashab Haji Hanafi and Hong Leong Beng Sinan Berhad 2016 8 CLJ. This presentation is going to be divided into four situations, which is facts, issue, judgment and commentary. Moving on to the facts of the case, the respondent and the appellant has entered into a hire purchase agreement that dated by 24 June 2009. The appellant has agreed that to hire one Mercedes-Benz with the registration number of WSH3131. The appellant has defaulted in making payments accordingly as per agreed in the agreement. Then the respondent then sent a notice of intention to repossess the car under the 4th schedule of HPA 1967 on 24th of April 2014 and subsequently has issued another notice on 10 May 2014. In 6 May 2014, the appellant has agreed to return the car voluntarily to the respondent, and subsequently, on 7 May 2014, the respondent has ordered a requisite to estimate the value of the car and other things that needs to be paid by the appellant during the defaultment of the payment of the car. On 22 August 2014, the car was later then sold by means of public auction at a sale price of 141 141,000 ringgit Malaysia. Moving on to the issue of this case
is whether the respondents are to be held liable for selling the car at a lower price by means of public auction. The sale of the car took place at a public auction where demand is relatively small and price level fall in subsequent auctions. The court ruled that the price of the car of the auction is reasonable, although the car market value was estimated to be RM 198,400 and the fee schedule notice dated 7 May 2014. The second issue is whether the demand for payment made by the respondent can be considered invalid and the amount claimed can be denied by the appellant. A review on the statement of claim helped the respondent discover that they have set out the details of the calculation that resulted in the outstanding sum after making the necessary deductions, particularly on payments previously made, auction sale proceeds, and as well as rebate. As a result, according to Section 16A of the Hire Purchase Act 1967, these extra fees are not considered as repossession charge. The third issue is whether the act of not delivering the agreement to the appellant will affect the respondent stand in this case. The court determined that the appellant's claims of non-receipt of the HP agreement and other notice was lacking in substance and unverifiable by evidence. According to clause 13 of the HP agreement, known as Exhibit CKH-1, any notice including the writ of summons and any statement of claim or any document in regard of any action in line with the agreement must be provided personally, sent by post or left at the existing business address. Moving on to the fourth issue. The issue is whether the vesting order needs to be served to the appellant when the respondent sells the car. This argument is regarded to be legitimate as Section 50 subsection 3 of the former Banking and Financial Institution Act 1989 expressly explained that the transfer would come into effect on the transfer date alluded to in the order of the High Court. Thus, the appellant's claim about not being notified about the vesting is immaterial in this case as the law is enforced to demonstrate that the vesting occurred irrespectively. Moving on to the last issue. The issue is whether the supporting affidavit for summary judgment application is defective. The appellant asserts that the respondent's affidavit is deficient because it fails to affirm the resources and justification for the declaration of intention and belief made therein. This is a violation of Order 14 Clause 2 of the Rules of Court 2012. The court on judgment in favour of the plaintiff against such a defendant on that claim or portion of the claim that is just in light of the nature of the remedy or relief sought. Moving on to the commentary.
I am going to explain about the commentary of our journey on this case. As referred in this case and focusing on the topic of Hire Purchase Act, there are some things that are actually worth highlighting based on the summary of the judgment of the respondent. First of all, it can be seen in the first issue when the appellant has used Section 16 of the Hire Purchase Act to justify that they are kept in dark when the auctions of the car are being held. 16 of the mentioned notice to be given to the hirers when goods repossessed. The interpretation and the use of this law are unreasonable due to the fact that Section 16 are used for repossession situation, not a situation where a voluntary action has been made to return to the car to the respondent. This cannot be applied to the appellant voluntarily returns the car without the respondent having to repossess the car, resulting in application of Section 16 becomes invalid. And the second would be when allegation has been made to the respondent, the burden has shifted to the appellant to prove that such action has occurred and on the grounds that the situation has affected the appellant. Denial when making an allegation is insufficient to prove that the appellant's claim are detrimental to his side. The appellant's ability to prove that the doubt on the respondent's part was not sufficient as it mentioned in section is valid to be applied. Thirdly, the respondent has followed the Hire Purchase Act and it was unreasonable for the appellant to believe that any actions made are affecting them just because the law is not on their side. It is important to follow the Order 14 of Rules of Court 2012, yet such an application must be made includes an affidavit in Form 13 to justify such claim. This is to verify the facts underlying the allegation or portion of the claim in which the application only to the extent of the amount of the damages claim. In conclusion, this case demonstrates the importance of understanding the interpretation of law and adhering to the Court Order 14 of the Rules of Court 2012.